Yes. Good morning, everybody. I, Dr. Meenakshi Kalra, welcome you all on behalf of the Supreme Court Advocate on Record Association to this lecture series. Today, we've all gathered here for one of the important exams of leading cases and for the upcoming AOR examination, where our esteemed speaker will enlighten us on Right to Die, Article 21, Criminal Law, Article 14, Constitution of India, and Fair and Independent Investigation under Article 21. We have the honor to have with us today Senior Advocate Gautam Narayan, sir. We welcome you, sir, and we're thankful to you for taking out time. We're showcasing live on YouTube, and if anybody has any questions, the same may be put in the chat box, and the same will be taken up in the end by sir. I now request our President SCAORA to please start with the session.
Morning, everybody, and warm welcome to Gautam Narayan, Senior Advocate, who fortunately for us had an extensive AOR practice. So he brings with him that combination of successful litigation practice as an AOR, both on the criminal and the civil side. And he has been closely associated with very large number of leading cases, along with his earlier senior, Dayan Krishnan, who is an acclaimed criminal law specialist. So it's an absolute pleasure to have you with us, and I'm very sure this will be a real masterclass for all of us. Welcome.
Thank you, sir. I now request our member executive, Reena Pandey ma'am, to please give an introduction about sir.
Good morning, everybody. Before we begin this session, it is my privilege and pleasure to formally introduce our esteemed speaker. Mr. Gautam Narayan, sir, is a distinguished senior advocate with over 24 years of experience practicing before Honorable Supreme Court of India and various high courts across the country. Before his designation as senior advocate, he served for 16 years as advocate on record. He specializes in constitutional law, administrative law, and environmental law, and has served as a standing counsel for the state of Chhattisgarh, as well as for the High Courts of Delhi, Madras, and Patna before Supreme Court of India. He has also held a position of additional standing counsel for the government of Delhi in Delhi High Court. In criminal law, Mr. Narayan sir has acted as a special public prosecutor in NIA and has represented premier investigative agencies including CBI and Delhi Police. His commitment to public service is further reflected in his ongoing role as amicus curiae before Delhi High Court in matters under Delhi Protection of Trees Act 1994. Sir has also dedicated representation of underprivileged individuals in criminal appeals before Honorable Supreme Court of India. Over to you, sir, now.
A very good morning to all of you. At the outset, I thank all the executive committee members of the SCAORA, Mr. Nair, Mr. Sharma, Dr. Kalra, Ms. Pandey, Mr. Giri, and others for giving me this opportunity to address all of you today. The SCAORA has over the years rendered yeoman service to the functioning of the Supreme Court and consequently to the dispensation of justice itself. It is without doubt one of the most important institutions in the ecosystem of the Supreme Court. Several AORs have gone on to become judges of the Supreme Court of various high courts across the country, have been designated as senior advocates, having acquitted themselves with great distinction and bringing laurels and glory to the institution of advocates on record. The present series of lectures organized by the SCAORA is just one more feather in the cap of the SCAORA, which is brimming to the full, according to me. Now, before I start dealing with the topic for today, there are a few prefatory remarks that I wish to make. The first being that the institution of the advocate on record is, to my mind, one of the most important cogs in the wheel of the Supreme Court. It keeps the wheel of justice dispensation spinning smoothly. Advocates on record are the vital cog and the vital linchpin between the judges of the court and the litigants. The judges of the court, therefore, place an immense amount of faith and trust and belief in advocates on record. The onus, therefore, lies on each one of you once you clear the exam to ensure that no quarter is given and no cause is afforded to anyone to raise any finger either at you or to the institution of advocates on record. We all know that in the recent past, the court has felt compelled to make certain observations with regard to the manner in which certain members of this institution have conducted themselves. The onus therefore lies on each one of you to ensure that such things do not reoccur. Please take your role and your responsibility with utmost seriousness and conduct yourself with the highest degrees of professional excellence and moral and professional rectitude. The last comment that I want to make is that this exam is quite unlike any other exam that you would have taken up until now in your academic and your professional careers. This exam is, to my mind, a life-changing moment, and I'm sure all of you have accorded to it the requisite degree of importance and priority which it deserves. With those comments now, let's jump straight into the topics for discussion today. We have before us 6 cases divided into 3 broad segments. The first being whether the right to die can be recognized as a facet of the right to life enshrined under Article 21 of the Constitution. Under this segment, we have the celebrated judgment of common cause reported in 2018, Volume 5 SCC, page 1. The second segment deals with the interplay and the intersection of Article 14 and the implementation of criminal law. We have 4 judgments to deal with under this section. The first being Navtej Singh Johar, the second Joseph Shine, the third Shakti Vahini, and the fourth being Sukhpal Singh Khera. The last segment deals with the issue of investigation into crimes and whether such investigation must comport with the guarantee of free, fair, transparent, and non-arbitrary investigation as contemplated and enshrined under Article 14 of the Constitution. I will now commence with the first judgment, which is the judgment in common cause. A short background to this judgment. Common cause, as you all know, is a NGO. It approached the court with a petition under Article 32, espousing a right to die with dignity to be held as a fundamental right and a facet of the right to live itself under Article 21. The petitioner contended that persons who were in a deteriorated state of health or were otherwise terminally ill should be permitted to execute what they called a living will and an attorney authorization, which could be presented to the hospital or institution where they were admitted, and necessary consequent steps could then be taken. Now, the background in which this judgment arose before the Supreme Court was a triumvirate of cases. The first in sequence being the judgment delivered in the year 1994 in P. Rathinam versus Union of India. In P. Rathinam, 2 persons, that is Rathinam and one Nagabhushan Patnaik, had approached the court, assailing the constitutional vires of Section 309 of the Indian Penal Code, which, as you all know, is the attempt to commit suicide. Rathinam challenged Section 309, while Nagabhushan, who had already been convicted of the offense under Section 309, assailed his conviction itself under that provision. The court held that the right to live a forced life could not be, the right to life under Article 21 does not include within its ambit the right to live a forced life. This judgment was then, within a period of 2 years, followed by the Constitution Bench judgment in Gyan Kaur versus State of Punjab, which is reported in 1996, Volume 2 SCC 648. In Gyan Kaur, the challenge was brought by persons who had been convicted of the offense of abetment to commit suicide under Section 306 IPC. And the challenge raised there was that when the principal offense of commission of suicide itself had been decriminalized, the offense of abetment to commit that offense certainly could not survive on the statute book. The Supreme Court repelled this contention. It overruled in terms the judgment in Rathinam, and relying on the judgment of the House of Lords in Airedale versus Bland, went on to hold that although the House of Lords had held that passive euthanasia or the withdrawal of life support was permissible as a common law right, the Supreme Court stopped short of saying so. The third in sequence of these two cases is the judgment in Aruna Ramachandra Shanbag versus Union of India, which is reported in 2011, Volume 4 SCC 454. This was an Article 32 petition filed by a friend of Ms. Shanbag. Ms. Shanbag had been subjected to a violent sexual assault in the very hospital in which she had worked for years and had been reduced to a vegetative state. It was contended before the Supreme Court, therefore, that life support to Ms. Shanbag should be withdrawn and that this was a right inhering in her under Article 21. Although the Supreme Court on facts repelled the prayer made before it, it went on to hold that in Gyankor, the Constitution Bench had in fact affirmed the view taken by the House of Lords and had therefore held that passive euthanasia was a permissible course of action. It therefore proceeded to lay down very detailed guidelines with regard to the manner in which such a right could be enforced or put into action. Now, while the judgment in Shanbag was delivered, common cause had already arrived at the doorsteps of the Supreme Court. Because of the judgment in Shanbag, the judgment in common cause, which was at that stage before a bench of two judges, was referred to a Constitution Bench. The Constitution Bench, which dealt with this issue, comprised of Chief Justice Mishra, Justice Khanwilkar, Justice Sikri, Justice Chandrachud, as he then was, and Justice Ashok Bhushan. 4 separate but concurring opinions were delivered. The first being Justice Mishra speaking for himself and for Justice Khanwilkar, and concurring opinions were rendered by the other 4 judges. I'll first deal with the main opinion rendered by Justice Mishra. Justice Mishra dealt with the concept of euthanasia itself and the distinction between passive and active euthanasia. He held, and I quote, "Euthanasia is an intentional premature termination of a person's life, either by direct intervention, which is active euthanasia, or by withholding life-prolonging measures and resources, which is passive euthanasia, either at the express or implied request of that person, voluntary euthanasia, or in the absence of such approval or consent, which is non-voluntary euthanasia." The court further noted the distinction between the two forms of euthanasia has been recognized the world over, and while most countries have today recognized and legalized passive euthanasia, there does remain a certain sense or degree of ambiguity with regard to the permissibility of active euthanasia and whether such a right should be given legal status. Justice Mishra then held that the right to refuse treatment is a facet of individual autonomy and the right to self-determination. He distinguished between suicide and the right to refuse treatment. According to him, although the consequence of both acts, that is suicide and refusal of treatment, is death, while suicide on the one hand involves a self-initiated positive action, a patient who refused medical treatment merely allowed the underlying disease to take over, and therefore he drew a distinction between suicide and the refusal of treatment. He then dealt with the right to die with dignity and held in terms that the right to die with human dignity must be held to be a fundamental aspect and facet of the right to live under Article 21. He then goes on to hold that passive euthanasia is justified under Article 21, and I quote, "to prevent a person from undergoing pain, suffering, and a state of indignity because of unwarranted medical support." Passive euthanasia, according to him, was meant for the avoidance of unnecessary intrusion in the physical frame of a person to create a smooth exit from life, and the individual, according to him, had the right to protect her dignity, even in death, by choosing to die sans pain, sans suffering, sans indignity, brought about by wasteful and purposeless medical intervention. Now, while Justice Chandrachud principally agreed with the view taken by Justice Mishra, he, however, had one difference of opinion. According to him, the justification for passive euthanasia propounded by Justice Mishra in the act versus omission dichotomy recognizes the nebulousness of this distinction, because according to Justice Chandrachud, and in my view rightly so, even the withdrawal or withholding of medical treatment or life-saving treatment is at the end of the day a positive act. And therefore, it may not be as simple as saying that merely by withdrawing or refusing treatment, I am letting the underlying disease to take over. The possible answer to this conundrum could be, to my mind, that if medical opinion suggests that the underlying disease is irreversible or incurable, then the freedom of choice must be held to be recognized in the person or the patient to refuse treatment. The most important contribution to the development of constitutional law by this judgment is the laying down of what is called Advanced Medical Directives, or AMD. In order to operationalize the right which the bench had recognized of passive euthanasia, the bench then laid down detailed guidelines in the form of Advanced Medical Directives, which is a legal document which explains one's wishes about the manner in which one would receive medical treatment or refuse medical treatment in the event that one were to become incompetent or incapable of dealing with the situation at some point in the future. The judgment lays down detailed guidelines about how these directives have to be issued, how it is to be recorded and preserved and given effect to. Now, it is important to note that at this stage, the judgment had involved an active role to be played by the magistrate first class of the concerned area, the JMFC. The JMFC was required to countersign the opinion of the medical board before authorizing the withdrawal of medical treatment. The judgment also laid down cases in which an advance directive could not be executed. What is to be done in such a situation? Now, the court expressly laid down that these advanced medical directives were merely guidelines and were to be treated as law under Article 142 till such time as legislation stepped in. Finally, I will now draw your attention to certain developments which have taken place post the judgment. Now, this judgment was delivered on the 9th of March 2018. Within a short span of time of less than a year from the delivery of this judgment, the Indian Society for Critical Care Medicine preferred an application for modification of the directions issued in the judgment on the ground that insurmountable obstacles were being faced in the implementation of the guidelines, primarily because of the requirement that such directives could be enforced only if they had been countersigned or approved by the JMFC. A subsequent constitution bench, headed by Justice K.M. Joseph, dealt with this modification application and went on to replace the JMFC or remove the role ascribed to the JMFC in its entirety and replace it with a gazetted officer. Secondly, the judgment also provided for two separate and independent medical boards. The first being a primary medical board, which gives a primary opinion, to be followed by a secondary medical board, which will deal with the opinion given by the first medical board. The problem with this judgment still remains is the difficulties that a person who is the next of kin, next friend or family of a person in a permanent vegetative state or who is terminally ill and yet incapable of relaying his or her wishes is that if the medical board were to hold against the withdrawal of life-saving treatment, the only recourse then left is to exercise the right of judicial review by approaching a court under Article 226. This, according to me, is not a very happy situation and only adds to the misery of the family which it is already undergoing. Now, I want to pose a few questions. Even after this judgment, what happens in a situation where after withdrawal of life support, a person who is in a permanent vegetative state does not die and continues to live, what then should be the recourse? What about persons who are suffering extreme pain or extreme distress due to a certain medical condition and who do not wish to live, but are not terminally ill in medical parlance or have not been reduced to a persistent vegetative state? What recourse do they have? Has the time come in our country to recognize a right to active euthanasia, as has been recognized in some jurisdictions, such as the Netherlands, Luxembourg, and Belgium? These are all issues that, according to me, require consideration. Lastly, I have scanned through the past year's question papers going back till about 2018, and I have found 2 occasions in which questions were posed on this topic. First, in the year 2018, a question was posed, and I quote, "What is passive and active euthanasia? Does Article 21 of the Constitution enable an individual to resort to passive euthanasia? What procedure needs to be followed for this purpose?" In 2022, the question which was posed was, does the right to life under Article 21 include within its ambit the right to die? What is the scope of life and liberty under Article 21? Is euthanasia permitted in India? Discuss in the light of Common Cause versus Union of India, 2018, 5 SCC, page 1. Therefore, I have attempted to deal with the issues that have been posed in these questions in these 2 years by giving you a broad overview of the scope and the context in which this issue arrived before the Supreme Court and what the court held, the evolution of law starting from Ratinam up to the modification of the judgment in Common Cause. I will now take you to the third segment. The second segment is a little detailed. I'll deal with it in the end. The third segment, which is the investigation of crimes and the requirement of such investigation to comport with the constitutional imperative under Article 14, was dealt with by the court in the judgment in State of West Bengal versus the Committee for Protection of Democratic Rights, which is reported in 2010, Volume 3, SCC, page 57. This is a judgment of another constitution bench comprising of Chief Justice Balakrishnan, Justice Ravindran, Justice D.K. Jain, Justice Sadasivam, and Justice Panchal. The issue before the court arose in the context of a violent physical assault on members of a certain political party by persons holding allegiance to the ruling political party in the state of West Bengal, or at least that was the allegation. As a result of this violent assault, the entire group of persons who were assaulted died, save and except for the complainant. The complainant then proceeded to register an FIR under Section 302 of the Indian Penal Code. The Director General of Police of West Bengal immediately directed that investigation be transferred to the Criminal Investigation Department for the CID. Now, what was shocking was, despite the lapse of over 2 months of registration of the FIR and the transfer of investigation, not much headway was made into the holding of people who are bringing to light the people who were guilty. Therefore, the Committee for Protection of Democratic Rights, an NGO, approached the High Court of Calcutta under a petition under Article 226 and sought the handing over of investigation or the transfer of investigation from the CID to the CBI. This prayer was vehemently opposed by the state of West Bengal. However, the judges who dealt with the case were incensed with the inaction displayed by the CID and consequently transferred investigation. The issue was then placed before the Supreme Court by the state of West Bengal by way of a special leave petition. The principal submission which was raised before the Supreme Court was this: could even a constitutional court such as the High Court direct transfer of investigation to the CBI, which, as you all know, is a special police establishment constituted and organized under the Special Police Establishment Act of 1946? Could such transfer take place sans the consent of the state government as contemplated under Section 6 of the 1946 Act? The court therefore framed 2 primary issues. The first being whether a reference to the CBI by a High Court for investigation into a cognizable offense could be made without the consent of the state government? And if so made, would such a direction be incompatible with the fundamental features of our constitution, namely federalism and the doctrine of separation of powers? The second issue which was posed by the court was whether the doctrine of separation of powers curtails the power of judicial review, which is inherent in superior constitutional courts such as the Supreme Court and the High Courts, and whether the exercise of judicial review could be taken to impinge upon the doctrine of separation of powers. The court dealt with entry 39, list 1 of the 7th schedule to the Government of India Act 1935, first and foremost. Entry 39 is today entry 80, list 1, 7th schedule. The court also had occasion to deal with entry 2, list 2, which deals with state police force and places such police force under the direct supervision of the state government. The court also dealt with various provisions of the 1946 Act. And after interpreting all of these provisions, went on to hold that the power of judicial review is a part of the basic structure of our constitution. The exercise of such power by a constitutional court, be it the Supreme Court or the High Court, does not and cannot be taken to mean an infringement on the right of either a violation of either the concept of federalism or impinging upon the doctrine of separation of powers. In fact, the court went on to hold that in our constitution, there is no strict implementation of the doctrine of separation of powers. Judicial review, according to the court in this judgment, was placed on a very high pedestal. Separation of powers, on the other hand, the court felt, in the modern era, did not mean a limit on the active jurisdiction of each organ of the state, but instead enjoined each of the three organs to prevent each other from falling into what it termed as inaction and ensuring that each of the other organs perform their functions in accordance with law. The court also held that a system of checks and balances was what is a fundamental facet of our constitution. It went on to hold that the power of judicial review conferred under Article 226 is much wider than the power under Article 32. It further held that in a federal structure, judicial review acts as the final arbiter for determining the limits on legislative power, and held that restrictions that were placed on Parliament by the Constitution and consequently upon the executive by an enactment of Parliament do not impinge upon the power of a superior constitutional court if compelled in the facts and circumstances of any case to direct transfer of investigation. In other words, what the court held was that the statutory limitation placed on the power of the central government under Section 6 to obtain the prior consent of a state government within whose territory a particular offense has taken place, investigation into which is sought to be transferred from the state police force of that state to any external agency. Such a restriction is not placed upon the constitutional power of a High Court or the Supreme Court itself, because the court held that it is the duty of such superior constitutional courts to zealously and vigilantly protect and safeguard the fundamental rights of citizens. Now, there have been several instances of the exercise of such power by the Supreme Court itself, even prior to the judgment in state of West Bengal. As far back as in the year 1994, in R.S. Sodhi versus State of UP, this power was exercised and investigation was transferred outside the state. Similarly, in the Taj Corridor case, that is MC Mehta versus Union of India, reported in 2003, volume 8 SEC, page 706 also, investigation was transferred outside of the state. In Narmadabai versus State of Gujarat, 2011, volume 5 SEC 79, the Supreme Court once again felt impelled to transfer investigation. However, the issue as to whether the High Court could exercise such a power was for the first time laid down by the Constitution Bench in this judgment, that is Committee for Protection of Democratic Rights. Now, recently, on the 15th of May 2025, the Supreme Court once again exercised this power and transferred investigation into a case of custodial torture and death of one person in Madhya Pradesh to the CBI. The court felt incensed by the fact that despite this being clearly a case of custodial torture and death, no headway was being made for over a year from the date of the offense. The court therefore held, relying on the settled principle of nemo judex in qua sua, that no one could be a judge in their own cause, and therefore the facts required transfer of investigation away from the state police to an external agency. Finally, an issue which arises is, we all know, and the Supreme Court has recently, in a judgment in CBI versus Altaf Mohammed, held that the CBI as an investigation agency is under immense strain and immense burden. What then would be the appropriate external agency to which investigation could be transferred by a constitutional court, given the facts of a case where the court were to feel that the state police was unable to discharge its functions? This is an issue that requires consideration. Now, as regards the questions on this topic, I have found a question posed in the year 2019, the exam held in June, and the question was this: what is the scope of the power of the High Court under Article 226 of the Constitution in directing investigation by a specialized agency? Would the High Court be restricted by any statutory requirements in the exercise of jurisdiction under Article 226? What is the effect of the exercise of power and transfer of investigation to an agency other than the state police by the High Court under Article 226? And what impact does it have on the federal character of our Constitution? Discussed with reference to State of West Bengal versus Committee for Protection of Democratic Rights. Once again, I've attempted to give you the broad aspects which you will need to highlight if such a question were to be posed to you. I now proceed to deal with the second segment, which according to me is the most crucial and important segment, dealing with four very, very important cases, which are important not merely because of the impact that they have had on the development of constitutional law of this country, but also from a sociological perspective, purely because of the impact that they have had on society at large. According to me, these judgments, that is Navtej Singh Johar, Joseph Shine, Shakti Vahini, and the judgments such as the Triple Talaq judgment, Shaira Bano, then Putuswamy, are some of the most important constitutional principles that have been laid down by the Supreme Court. Let us first deal with the judgment in Johar. A brief background. This issue was first raised by the Nas Foundation before the High Court of Delhi. The challenge raised was this: according to the petitioner and NGO, to the extent that Section 377 of the Indian Penal Code sought to criminalize consensual sexual acts between consenting adults, it was violative of the rights of LGBT persons under Articles 14, 15, and 21, and therefore was clearly, in their view, unconstitutional. The court agreed with this challenge. A division bench of the High Court dealt with this challenge, agreed, and interpreted sex as falling under Article 15, sub-Article 1, to include within its fold sexual orientation. It rejected the justification of social morality and held that in such situations it is constitutional and not social morality that must determine the true expanse and scope of fundamental rights. This judgment was then brought up before the Supreme Court. Unfortunately, the Supreme Court in Suresh Kaushal reported in 2014, Volume 1, SEC, page 1, reversed the view taken in Nas Foundation by the Delhi High Court. The view taken by the Supreme Court in Suresh Kaushal was this. The court felt that Section 377 regulated sexual conduct regardless of gender identity and orientation, and therefore the question of discrimination did not arise. I think a fallacious reasoning, but be that as it may, the court went on to hold that LGBT persons constitute a minuscule fraction of the country's population, in as much as only 200 persons have been prosecuted under this provision since its inception. And therefore, the court felt that the provision could not be held to be unconstitutional. This issue was therefore highlighted once again and raised before the court in a writ petition filed in the year 2016 by 5 well-known persons: the Bharatnatyam exponent Navteej Singh Johar, Sunil Mehra, chef Ritu Dalmia, the co-founder of the Nimrana chain of hotels Aman Nath, and a business executive Aisha Kapoor. They contended that identification of a person as a part of the LGBT community for a declaration that the right to sexuality, right to sexual autonomy, and the right to choice of a sexual partner were all intrinsic elements of the right to life guaranteed under Article 21. They therefore sought a declaration that 377 was unconstitutional. Once again, the Constitution Bench comprises of Justice Mishra, Chief Justice Mishra, Justice Khanwilkar, Justice Nariman, and Justice Chandrachud and Justice Indu Malhotra. 4 opinions were delivered. Justice Mishra spoke for himself and for Justice Khanwilkar, while the other 4 judges gave separate but concurring opinions. Justice Mishra first and foremost held that our Constitution is a document which has an organic character and expounds progressive rights. He held that the Constitution aims at a society where every person has equal worth and can grow to realize his or her potential. According to him, the duty was imposed upon courts to realize this constitutional vision of equal rights in consonance with changing and evolving times. According to him, it was the duty of courts which assumed greater responsibility in cases which pertain to violation of rights of persons or classes of persons who had been subjected to humiliation, discrimination, and separation and violence by the state itself and the society at large, or their own families. He also discussed the doctrine of progressive realization of rights. According to him, the Constitution is a living document and needs to evolve to keep pace with the demands of a changing world and a changing time. Now, this is a raging debate. 2 of the most eminent judges of the US Supreme Court engaged with each other in a long-standing discourse on this very issue as to whether a constitution, a written constitution such as ours and as available in the United States, is something that is etched in stone, as was the view held by Justice Anton Scalia, or whether a document such as the Constitution must be given an evolving interpretation and must be treated as a living document as held by Justice Ruth Bader Ginsburg. Thankfully, we seem to have adopted the latter view, that is the one adopted by Justice Ginsburg. And in this judgment, the majority has held that the Constitution is an organic document, must be interpreted in order to bring it in sync with the needs of the modern era. Justice Mishra then expounded on the aspects of dignity and liberty and privacy of individuals. According to him, sexual orientation of an individual is like any other biological function. It is ingrained and it is innate. It is not subject to the choice of a person. And that being said, it becomes a part of a person's constitution. He recognized that the right to privacy, which had already been expounded by the judgment in the nine-judge judgment in Puttaswamy's case, protected sexual orientation as a part of the right to privacy, which, as you all know, has been elevated to the status of a fundamental right in Puttaswamy. According to him, the use of the expression against the order of nature is alien to our constitution. He held that the provision is manifestly arbitrary in as much as it violates the ethos of Article 14 for the reason that it draws no distinction between consenting acts and non-consensual sexual intercourse. He held that Section 377 did not constitute a reasonable restriction on the right under Article 19(1)(a), and in fact, to the contrary, has a chilling effect on the exercise of such right. He further held, and this view is echoed by Justice Narayan, that the punishment enjoined under Section 377 was disproportionate in as much as punishment was imprisonment for life. The second opinion is the opinion of Justice Narayan. Justice Narayan held once again that Section 377 is manifestly arbitrary. He says that it is mired in what he calls Victorian notions of morality, which can no longer be justified or held applicable in our constitution. According to him, the right to privacy is a fundamental human right, and 377 has a chilling effect on the exercise of such right. He also rejected the concept of presumption of constitutionality as was espoused in the judgment in Kaushal. And he held that since Section 377 was a pre-constitutional law, such a presumption could no longer be attached in a situation such as this, where a challenge was mounted to the violation of rights under Articles 14, 19, and 21. Justice Chandrachud's opinion, to my mind, deals with a very important aspect not dwelled upon in the other two opinions, namely the scope and ambit of Article 50 and the issue of non-discrimination. Justice Chandrachud recognized that instances of discrimination on the basis of sex had come to be upheld by courts on the basis of a formalistic, what he termed as a formalistic interpretation of Article 15, according to which Article 15 prohibited discrimination only on the basis of the grounds mentioned therein, including sex. But if the discrimination was on grounds other than sex, such as marriage or pregnancy, such discrimination would not be illegal, as was held by the court in Air India versus Nargesh Mirza. Justice Chandrachud therefore held that prohibition of same-sex relationships under Section 377 was based on gender stereotypes associated with sex and gender, which hold that men are unemotional, socially dominant breadwinners and are attracted to women, and women, on the other hand, are emotionally and socially submissive caretakers. He therefore eschewed the resort to such stereotypes and went on to hold that since discrimination based on sexual orientation was ultimately based on unhealthy stereotypes about sex, it could no longer be sustained in the modern era. Justice Indu Malhotra has concurred with the view taken by Justice Mishra. She has held that Section 377 is violative of the right to live with dignity, the right to privacy, the right to health, and therefore is violative of Article 21. She also held that the provision is violative of Article 19(1)(a). Now, in the past year's papers, I have found a question posed in the year 2023 on this issue, namely, summarize the reasons stated in Navtej Singh Johar for declaring Section 377 as being violative of fundamental rights provided under Articles 14, 15, 19, and 21. I think I have given you a broad understanding of this judgment, and if such a question were to be posed, it would be apposite to refer to at least the judgments of Justice Deepak Mishra, Justice Nariman, and Justice Chandrachud. I will now proceed to dealing with the judgment in Joseph Shine. Joseph Shine is a judgment delivered by the very same Constitution bench not more than 21 days after the first judgment. The judgment in Nate Johar was delivered on 6 September 2018, while the Joseph Shine judgment was delivered on the 27th of September 2018. The reasoning, therefore, the reason why I'm mentioning this is the combination was the same. The judgment was delivered within a short span of about 20 or 21 days. The reasoning, therefore, you will find is primarily the same. The issue which arose before the court in Joseph Shine was the constitutional validity of sections 497 of the Indian Penal Code and section 198 of the Criminal Procedure Code, both of which, as you know, criminalized the offense of adultery. The reasoning and foundational principles laid down in Joseph Shine, by and large, echo the view taken by the same bench in Navtej Johar. Justices Indu Malhotra and Justice Nariman, after having traced the evolution of this provision, observed, and rightly, that it is premised on an archaic notion that a wife is the property or chattel of her husband and therefore has no independent autonomy or rights inhering in herself. Obviously, such an interpretation cannot comport with the foundational values of our Constitution under Articles 14, 19, 21, which require all persons to be treated equally on an equal footing, regardless of their gender. Therefore, it was held that Section 497 was premised on Victorian notions of the status of women in the family. Accordingly, all the judges concurred in striking down this provision and holding that the dignity, the privacy, and the autonomy and the choice of a woman can be adequately protected only if such provisions no longer exist on the statute. The next judgment, a very important judgment to my mind, a judgment now delivered by a bench of 3 judges, that is Chief Justice Mishra, Justice Khanvilkar, and Justice Chandrachud, namely the judgment in Shakti Vahini versus Union of India, reported in 2018 Volume 7 SEC, page 192. This judgment dealt with, at that stage, what was a spiraling problem, khap panchayats, honor killings, and held that such instances had no place in contemporary modern India. They had no place in a constitution such as ours. The court held and recognized a right to marry a person of one's choice. The court laid down a slew of directions. The court also noticed the fact that the Law Commission, in its 242nd report, had been constrained to note that despite a query raised by the Law Commission, no state had responded to the Law Commission with regard to the figures of such honor killings within their respective territories. The court therefore laid down very robust and important guidelines, which can be divided into 3 broad silos: preventive measures, remedial measures, and punitive measures. I will highlight a few of these. Under the head of preventive measures, the court required issuance of directives to the superintendents of police of districts in which honor killings have historically taken place. It enjoined such SPs and district administration to promptly inform the police regarding a proposed khap panchayat. It required the SP or the DSP or a senior police officer to interact with members of the khap panchayat and to impress upon them that such a gathering was illegal and impermissible, and to issue appropriate directions to the jurisdictional police force to be vigilant. It held that if, despite such efforts, the meeting does take place, the DSP of the district was required to be personally present and to caution and warn the gathering not to take any steps to harm the couple in question, and that they would be held personally liable if any such action were resorted to. The preventive measures also enjoin sensitization of law enforcement agencies to proactively identify and protect and prevent such violence. It also requires the creation of an institutional machinery of all stakeholders to put in place a framework to prevent such violence from occurring. Next, remedial measures, which are, as laid down by the court, the prompt registration of FIRs, taking of immediate steps to protect the safety, the security, and the life and limb of the couples in question, facilitation of registration of their marriage, provision of accommodation at nominal rates, investigation into complaints to be conducted by an officer of the rank of at least an assistant superintendent of police to be supervised by a DSP. Lastly, the punitive measures. The court required resort to departmental and disciplinary action against officers, both civil and of the police force, for failure to prevent any such killing from taking place or failure to institute criminal action promptly and to carry it to its logical conclusion. It also required the creation of special cells in every district to receive complaints of harassment, constitution of 24-hour, that is round-the-clock helplines, and constitution of fast-track courts to expedite trials into such cases. The last judgment that has been placed for discussion today is the judgment in Sukhpal Singh Khera. Now, in this judgment, the issue which arose before the court was whether a trial court has the power to summon an additional accused, and when should such power be exercised. Should it be exercised before the conclusion of trial, which means, as you all know, the pronouncement of sentence, not the judgment whether guilty or not guilty, but pronouncement of sentence. Secondly, where a situation of an absconding accused leading to a splitting of trial takes place, can an additional accused be summoned, and at what stage should such a summoning order be passed? The court held that summoning orders in such cases should be passed either before the judgment in the trial which is taking place is delivered, or at the commencement of the trial of the absconding accused on the basis of evidence which has been brought forth in such subsequent trial. This judgment, to my mind, lays down a very important set of directions with regard to the manner in which the court concerned is to exercise its jurisdiction to summon an accused. That now brings me to the end of the topics for discussion today. I wish you all the very best. I hope that all of you are able to ace the exams that you will be taking in a few days from now, and will become proud members of the select class of advocates who have brought glory and honor to the Supreme Court as an institution itself. Wish all of you all the very best.
We don't have many questions today. I think you already captured all the topics very extensively. So I'll just end with the vote of thanks to you, sir. I, on behalf of the Supreme Court Advocate on Record Association Executive Committee, I extend a heartfelt gratitude to you, sir, for being an esteemed part of the lecture series 2025. Your illuminating insights on the judgments and related topics have been invaluable, and your expertise in highlighting the important paragraph of criminal law for the exam will undoubtedly be as to host this lecture will give in-depth knowledge, providing us the first-hand understanding of to excel. Your thoughtful analysis provided important questions answered in research. I appreciate your for having given.
Thank you.
Thank you, sir. Thank you.
Thank you. Thank you.
Thank you, sir. Thank you, sir.
Thank you, sir.